Hello, hello, hello. I'm back. This video is part two, setting a solid foundation, in particular, the endorsement and return of birth certificate. Now, remind you people that paperwork without the understanding is a waste of time. That's why I emphasize understanding the principles and the concepts. We'd love to provide templates for people to use, but if they have not the understanding, it's a crapshoot at best. And it's not that the templates do not work, but it is impossible to know all of the variables that may throw one off balance. It is a difference between one who knows how to fly a plane and one who was told how to fly a plane but has never flown a plane. If one truly is with the understanding, she can draft his or her own paperwork and dispense with the templates. She will be able to respond to the variables that may come up on the fly. One thing about using templates, keep it in mind the governments are watching. 20 years ago, a lot of people, we were doing acceptances, not me so much. I was still in learning curve stage. And but there's a lot of people doing acceptances, and these acceptances were going through. No problem. All of a sudden it stopped. The government caught on what was going on, and people were just copycatting. And so they've changed things a little bit. They're basically testing. If you really know what you're doing here, then you know how to overcome these variables, what I call the variables. So as it is, if the government receives papers from people that are basically the same, they will know that this is some sort of internet copycat stuff and likely toss your papers in the garbage. No joke. Using templates is a sure sign you lack the knowledge and the understanding, and you're probably unlikely to be able to stand on your own 2 feet when questions are challenged or tested. And do be prepared to be tested. That's why it's very important to have the understanding of the principles and the concepts. Now, there's a little blurb in our first video, Intro to Trusts, States, and Securities. And I'm curious how many people read it and thought about it. It is exceedingly relevant. And here is that quote by Romley. And listen up, people, and review it if needs be so you get it, that aha moment. Here's that quote by Romley. The only way to confirm equitable title is to grant legal title. The one who accepts legal title accepts and confirms that the one granting it must have been the owner in the first place, the true, real, outright owner. Legal title becomes the written confirmation of equity. Did you hear that? The grantor is the owner of the property, the real owner. If the trust was to collapse, it would go back to him, barring any other terms or conditions. And these times, real owner of the securities. The acceptor of the grant holds the property, the securities, as trustee, and therefore is the legal owner. Whenever a property is registered in the name of your public estate or a name deriving from it, you granted it. So although this journey began for us with Mom being the grantor of the certificate of live birth, the statement of live birth, after that, you are knowingly or unknowingly the grantor. This is evidenced by your signature. The only thing of man or woman that's in that system is this signature. This is what they call a biometric marker. They get that there's other things like DNA, but it's the signature that they need on these documents. And that signature can also be verbal. Hence why we don't appear in court, because these are verbal signatures, basically verbal endorsements. So aside from the fact that this is the name of a child on the birth certificate, why may you want to return that certificate with proper endorsement? We should have endorsed the certificate and returned it when we hit 18 years of age. The day I was a man. I didn't do that. I carried on as if nothing happened, as if nothing changed. I went on playing a person, a creature of the legislature, subject to the laws, the rules, and the regulations. Now, the reason for returning the birth certificate at the age of 18 is not only because one turned 18, it is the claim being made. Sort of like handing over a claim ticket for a jacket. It is what it is. And in this case, it is not, if it is not done on a timely basis by age 25, before the Sedicave Act kicks in, the claim process is changed. Now, something for people to think about. Man cannot make the claim as a person, and man cannot enter the venue except as a creature of the legislature, a person, which I can't speak for you, but I don't want to do that. And this is where the proxy comes in that I've mentioned. Our next video, part 3, setting a solid foundation, we will touch on the proxy as well as the security agreement that brings it all together. And this is how we can take control of things in Wonderland without being in or of Wonderland, other than, like I say, by our signature. Now, a couple points of interest here. It is vital that people let it sink in that there is no substance in this system. There's none. It's form only. Get that in there. Stop thinking about the stuff, the substance. We're not in there. Trying to fit man, car, house, gold, silver, any kind of substance into the system is a waste of time. When they took the gold and the silver out, that's when they took out the pardon me, the substance. Look on your food, this all comes in a box. They did a study in the 1950s. They fed some rats the box and some rats the cereal within the box. It was determined that the rats that ate the box were better off than the rats who ate the cereal. I kid you not. Think about it. And people have it in their minds that personal property consists of their belongings, the things you see here, the headphones, so on and so forth. TV, fridge, stove, things of substance. This is not so. They have it in their minds that the house or the land is real property. They list these things as assets and say bankruptcy proceedings. Not limited to that. That's just one place. They'll put down the house, the car, the bank accounts, assets, liabilities, so on and so forth, right? That's what people are thinking. But in this system, it's not that at all. But the people are correct in their thinking, except it is not about these things in the system, not in Wonderland. It's form only. If you've ever seen the movie Alice in Wonderland, it's a real live girl going into a form only world, cards, make believe stuff. And she had no business being in there. And finally, she figured that out and that they had no power and she got out. So I want to read you something here that came from a forensic auditor. And this is from an audit that was shared with me from November 2020. This is a quote from the audit. It's a good audit. It's with respect to a mortgage, doing the tracing, the paper trail. This concept is from ancient English common law, codified by most states as the UCC. For notes, promissory notes, which are securities, a note is personal property, form only. Think Personal Property Security Act. And also from real estate law and practice for the mortgage, a mortgage is not personal property. It is real property. So I see out here in the world of substance, we have names for things, but in the world of Wonderland, although these things sound the same, they're talking about different things. They're talking form only. Out here in God's kingdom, substance. In Wonderland, form only. And the entire system is Wonderland system. Got to get real straight on that, I suggest. You should also investigate the government. The public has no money, no credit of its own. It is bankrupt. To raise money, they make pledges and promises. These pledges and promises are backed by our public estates, which are backed by our productivity, our time and our energy. The public, the governments are not able to pay for anything without shifting that burden onto the people. And people, it is your public estate. You are the sole contributor. It is not the duty of the trustee, the government, the custodian, or the securities intermediary to provide the credit, the funding, the money, which is debt. My point here, if the government can make pledges, promises backed by our estates that are backed by us, our productivity, so too may we do the same for our good and benefit, but not directly. Get wrapped up in that word benefit there, who I'm the beneficiary. Remember, man does not exist in the system, so he cannot or best not claim to be the beneficiary of it. We take control of the goings on in Wonderland without being in it or of it. In so doing, I control the form. I control John Paul Smith, all caps, registration number. I control John P. Smith, SSN number. I put up the security for set off, settlement of the accounts. I control the substance. I get the use and the enjoyment of the substance with no encumbrances. For me, this is the return of equity, the balancing of the accounts, the benefits, so-called. Now think about it. On paper, I own nothing, but I have control. So if I have control of the form, I have control of the substance. So although on the form on paper is the beneficiary, if I'm in control, I get the benefit of having that control, which means, like I just said, I have control of this, the form, I control the substance. So that's my benefit. Nobody can touch it, and there's no taxes or no encumbrances on it whatsoever. But think about that. I'm going to read something here from Securities Transfer Act, which is also UCC Article 8501D3. A person is to be treated as holding a financial asset directly rather than as having a security entitlement with respect to the financial asset. If a securities intermediary holds the financial asset for that person and the financial asset A is registered in the name of, payable to the order of, or specially endorsed to that person, and B has not been endorsed to the securities intermediary or in blank. We don't want to be holding that financial asset directly. That's the target on our backs. As per the Vital Statistics Act, the birth certificate bears the name of a child, and a child is a person under the age of 18 years. What the foregoing from the Securities Transfer Act is saying, holding financial asset directly, once the birth certificate is endorsed to the custodian of the financial asset, being the registered certificated security, the foundation security we've talked about here, so as to convert the custodian to a securities intermediary, the person named on the birth certificate becomes the entitlement holder, registered in the name of, right? The financial asset is registered in the name of that person. If man claimed to be the entitlement holder, then he must be the person named on the certificate and nothing changes for him, because that's how people have identified themselves from the get-go, and in part how we got ourselves into this mess that we're trying to get out of. Now, if the securities entitlement, once the securities entitlement is established by endorsing that birth certificate back to the custodian to convert him to a securities intermediary, once that is done, then the person on the certificate can assign that. So if the securities entitlement is assigned by the said person to a proxy / person under man's control, government has no say in the matter here, that's proxy. It doesn't have its tentacles in it, cannot presume it to be a trustee, which is what they presume all these other things to be. Now we're talking, this is how we can be in it, but not of it. When I mean in, I mean control, but not of it. And that's easy to do. With respect to the assignment here, I'm talking about to sign for the person, because we have signed for the person from the get-go. In other words, you go into a bank to get a loan, you're signing the papers, you're not signing for yourself and binding yourself technically. If you don't know what's going on, then you are, but you're signing for the person, you're signing for the estate, or you're signing for the straw man, you're signing for the debtor. Think authorized signature. Now, I've heard people claim that a birth certificate is a credit item, that they can credit accounts with it. Just want to clarify something on that. This is wrong thinking based on a lack of understanding. Remember, I said the public is broke, it has no credit of its own. I want to share a story here of a friend of mine, Sean, who was in a public court this number of years ago, 4, 5, 6, I don't remember exactly, but it's just a traffic charge, minor offense. And anyhow, so on the first day going into court, first appearance people would call it, although he never actually appeared because they never crossed the bar. But in any case, he walked in and he walked right up to the provincial prosecutor and presented the birth certificate saying, I present this birth certificate not as evidence of my identity, but evidence of my interest. and I'm here to release my interest for the settlement of any and all charges. Short story is, the case was done. Boom, he got his butt out of there. But what happened here? Let's work with this. First off, he says it's evidence, not evidence of my identity. So the certificate is not identifying him as that he's some sort of interest in the equation here. He said, remember, he said it's evidence of my interest. So the interest is not pointing to him because he said it's not identifying me, and that's a true statement. That's a true and accurate statement. He said it's evidence of his interest in the birth certificate itself. So therefore, the birth certificate itself is not the interest; it's claim to the interest, is what he's saying here. And the interest, of course, is the foundational security, the certificate of live birth. So when he presented the birth certificate for the settlement, he was not to settle the charges. He was not authorizing the prosecutor to draw credit from someplace. Public doesn't have any, and Sean didn't come in with any, so there's no credit on the table. What he did do, and this is why what he did there is not the proper way to approach these situations. It was based on our understanding at the time, but what he did there was he gave them a banker's acceptance. By saying I release my interest for the settlement of any and all charges, he authorized them to build his estate, to tap into his public estate, the John Paul Smith registration number, so that they could put that estate up as the surety to underwrite their securities, their bonds, thereby making their securities, their bonds, good and marketable. Okay, that's what happened there. And so they go get the money off of these to market these things, securitization, so on and so forth. In the meantime, the debt is sitting on his estate. So though he got his butt out of there, from an accounting perspective, it's not the proper way to deal with things. He could have just said, yep, the estate doesn't consent to underwrite your bonds. You're the authorized representative, you're there, you have that power. So he wasn't releasing any credit. And the other mistake is when he said that, he gave them a blank check. He didn't say, I'm for the settlement of any and all charges. Now I need to know what the amount is so we can be specific to the amount being released here for settlement. He didn't do that either. So when they tapped into his estate, build his estate, put his estate up as surety to underwrite their bonds, he didn't stipulate an amount. So now they can go behind the scenes going, well, he didn't say an amount here, but he's authorized us, Juan Donnelly, blank endorsement, to put his estate up as a surety, so they could make the charges for whatever amount they want. Maybe they did, who knows? So it's really not the way to deal with it. But my main point here is that, well, that's what happened there. People need to understand or get a grip on that the birth certificate actually is not pointing to a source of credit somewhere, and the birth certificate itself is not a credit instrument. It's not capable of carrying, it's not a financial, has no inherent financial value. If people have received letters from the government without in respect of that many, many times, and it's true, it has no financial value. We'll get to that. Last but not least here, as per the Securities Transfer Act and UCC Article 8, a securities intermediary must agree to be a securities intermediary. You can't just force it on someone. Well, there is one who has already agreed in government, who has agreed to be a securities intermediary. Doesn't need to be forced. They've already accepted that. Remember, intention of government is to register births. They intend to receive these registration of live birth securities, these certificate of live birth securities. It's their intention. It's the law. When they did that, like I say, they took it into custody. At that point, custody means not the owner. If I'm in custody of something, it's not mine. It's either mine or I'm in custody of it. If I'm in custody of it, I don't own it. So people may want to rethink that word custody, but that's how it starts. So it's in their custody. Now you want to, in order to convert them from custodian to securities intermediary, you need to endorse that certificate to them, as I just showed you. And now you've established a securities intermediary. So that's what I mean by they've already agreed to do that. That's about it for this one. And just a word of caution. I've heard some folk on the internet talking about they want to go out there and claim the national debt. You know, they want to think they're doing people favors. I'm going to take over the whole national debt. But the last guy who did that is in jail. And the reason he's in jail is, you see, it's not any one individual's debt to claim. Everyone has a share. So people want to go after the national debt, you can only go after your share of that national/public debt, not the whole thing. It's not yours to claim. It'll go down. This is, like I say, paperwork without the understanding of the principles and the concepts is a waste of time. Taking action without the understanding of the principles and concepts can end you up in jail, lose your house, lose your family, lose your job. You know, at a situation, one last thing here, a 3 years ago, a fellow got fired from General Motors. And he got fired from General Motors because he was basically, and I misstated this in a previous video, claiming to be a human being. Well, eventually General Motors fired him saying, we don't hire human beings. And the same day that we heard about that fella, we actually had a piece of paper from the government with respect to if a corporation is letting go of an employee, you know what they refer to the employee as? An entity. So you see, there's no substance in that system. It is form only. This whole reclaiming securities process is so man can take control of what's going on in Wonderland without having to be in or of Wonderland, except to the extent of the pen. They need the signature. If you don't put a signature on the promise to pay, it's a worthless piece of paper. For example, again, promise to pay is a security. So it's really important that people get a grip on that. And again, that's why we have the proxy. The proxy will be in and of the system. Will be in the system, not of it. But the proxies, is who the person named on the certificate would assign its interest to the proxy. So now the proxy can step in and control the situation. So man controls his proxy, and the proxy controls what's going on in Wonderland, keeping man out of it. That's the kind of information that we provide with the Reclaim Your Securities information package. And with these videos, hopefully it's helping people to some extent get a grip on. So anyhow, I think that's it. That is it. Lovely, beautiful sunny day. I'm going to get my bike out and go for a ride. Hey, just one more thing, folks, with respect to just an addendum here. I talked about my friend Sean and the traffic court situation. Just want to explain that a little bit further for you. See, when they put his estate up as the surety to underwrite their securities, to make their securities good so they could market them, sell them, and get the money, that money actually belongs to Sean, his estate. And this is why when we reclaim our securities, that's what we're going after. It's like with the banks. They're doing the same thing at the bank. What's going on in the court? The banks are doing the exact same thing. The whole system is doing the same thing. All the transactions, although they look different, behind the scenes, they're all the same. Everything they're doing is to tap into our states, get our states on the hook. What's your name? What's your date of birth? Ties back to the original registration. When you're in court and they're asking what's your name, what's your date of birth? That's what they're doing there. They're identifying the estate. And by you giving them this information and just appearing in court, as I say, authorizes them now, legally speaking, to plunder your estate. It's called legal plunder. So it's the same game right across the board. So in that case, in that kind of situation, it happens all the time, every day. So just to be clear here, when they're tapping into our estates, getting our consent, knowingly or unknowingly on our part, to put our estates up as the surety to underwrite their securities, their bonds, so on and so forth, their securities, that whatever money they raise from that belongs to, in Sean's case, his estate, in your case, to your estate. And with reclaiming your securities, that's what you're going for. Hey, that's my money. Whatever money you guys raised off of your securities back by my estate, that belongs to me. This is all part of the reclaiming your securities process. And just to put that in greater perspective, the reason we have, people talk about there's the 99% that are poor, if you will, and the 1% are way up here. That's because of this right here. a lack of knowledge on the part of the people. It's legal plunder. It's what it is. It's legal plunder. It's legal what they're doing. It's not morally correct. No. Is it good faith? No. And good faith, by the way, is an absolute requirement in the securities transfer legislation and UCC Article 8, which they're not, as I say, there's no, it's just plain out, flat out legal plunder. So because of our lack of knowledge, all of the wealth of the people, trillions and trillions of dollars have shifted from you and I to the 1%. So when we step up to the plate here and start to reclaim our securities, we can start to take that back from these 1%ers. I'm not saying it's going to be an easy task, but that's the real root cause, and that's the real root solution to all of this stuff that's going on around planet Earth. It's been going on for a long time, and all this nonsense that's going on these days. So, anyhow, with respect to the finances, the financial, it's shifting the wealth from all the people to this 1%, purely because of our lack of knowledge and understanding what's going on. And so, anyhow, it's part of the Reclaim Your Securities information, how you can, once you have the understanding of the principles and the concepts, how you can start going after that money and get that check. And that check would not be payable to you, it would be payable to your estate. All right, people, I'm just going to go a little bit more into, how you doing? A little bit, going to go into here how they're actually basically stealing our wealth, if I can put it that way. And what I mean by wealth is the fruits of our securities, whether it be directly from our securities or from securities they've leveraged against our securities. That's how they're stealing our wealth. Going to a bank, and here in Canada, anyhow, or to open up an account in Canada, you can actually use just a birth certificate. Not that it matters, but just to work with that, and understanding that the birth certificate is claimed to the financial asset, which is the registration of live birth that represents your public estate and your interest, the surety. So a bank, they want to, okay, so you show them the birth certificate, so now they've got all the information they need: name, date of birth, registration number, to connect to your surety, the estate. But when they open up the account, it's going to have a different name on there, a different account on there, a different trust on there. And it's going to be, so, birth certificate has John Paul Smith, registration number that connects to that puts up the surety, the public estate. But when it comes to time to opening an account, it'll be something like J.P. Smith. But that's going to be the debtor name. That's going to be the one. It's going to be connected to your social insurance number. And even if you don't give your social insurance number directly at the bank, which for banks here in Canada, they cannot demand it. The only time is if for savings, that sort of stuff, because you're making money now on money, interest on money. They can go to the credit reporting bureaus. There's other ways they can get that number, and there's lots of information that they're fishing for when you're opening up that account. Some of them are asking, do you authorize them to do a credit check, this and that, the other thing. So, they have a way. So the point being is the presentment of the original document, i.e. a birth certificate, gives them the information they need to identify the estate. Same thing going on in the court when the judge says, what's your name? What's your date of birth? Name, date of birth. That's connecting back to the security / your public estate, the surety. And but what's actually being charged is the debtor. Same with the bank account. When you open up the bank account, which is going to lead to charges, charges for using the bank services, the account services, so on and so forth, or whatever. It's going to be the name on that will be the name and the SSN or SIN number, and that's the debtor. So they charge the debtor. They don't charge, like I said previously, they don't charge the estate. They charge the debtor, and they get to the estate through the debtor. If you authorize it, if we authorize it, and we authorize that in a number of ways: just sign, start paying the bills, show up in court, make an appearance, sign a promise to pay, promise to appear. Any number of things. There's basically 3 ways to get your consent, and like I say, that's actually a banker's acceptance. Basically, you're authorizing them. Yep, go to my account and take whatever you need. but again, charging your account or putting your estate up as surety to underwrite their securities, making their securities good. And so courts do it, banks do it, governments do it. You have a social insurance number, SSN number. Again, you need a birth certificate to do that. Connects back to your surety public estate. But this is the registration number, and then a name could even be the same, John Paul Smith, but it will have that SSN or SIN number. So you see, it's 2 different accounts: surety, debtor, and so it's our lack of knowledge of what's going on there that's, as I say, how there's basically plundering. It's legal plunder. Theft, but it's legal, so it's not theft. Your driver's license has all that information on it already that they need. It taps in the state. Bottom line is you couldn't possibly have a bank account or any other account out there where you have to present identification, open it, or identity documents, but not actually identifying you. but by your signature and your consent, informed or otherwise. Again, they got the information to tap into your estate to put it up as surety for the debtor, and then they charge the debtor. So you see, and then so that's how they get everything to work. That's basically the means. So surety, debtor, and banks, government promises to pay other securities, whatever, opening up the account. That's where they start to get the information, and they know what to do with that information. And but it's all of ours. What the whole thing they're doing is based on our securities, our property. We don't recognize it as that. And again, presumed abandoned, presumed general deposit. General deposit title goes to whoever. Special deposit, it stays with the depositor. So in other words, title doesn't pass. Presumption of abandonment. I mean, clearly, if somebody knew what a promise to pay was, when you go into a bank and hand a bank a promise to pay for $500,000, if you knew what it was, you wouldn't turn around and let them lend it to you and then pay that back plus interest. Who the heck would do that? No. It's a money changer, right? That's what they are. They're money changers. You just talked about the money changers, but they are the money changers. They convert security, one form of securities that don't circulate as money, into another form of security or something backed by security, electronically, that does circulate as money, digits in the computer system. It's nothing physical there whatsoever, but behind the scenes there's something somewhere. It's just not birthed out of pure nothingness. I know people say money out of nothing, and in a way it is. It's really it's based on the promise, and so if that's nothing, that's nothing. But it's not made out of substance, that's for sure. And the bank is not lending anything of its own, or when a bank says it's lending its depositors money, yeah, you're the depositor. You deposited the note, so they're not necessarily lying there. Though at the branch level they may not understand that, but so. When they say they lend their depositors money, you're darn right to do. You give them a promise to pay the deposit, general deposit, but you're the depositor, right? Initially, and so yeah, they lend you your in that sense, they lend a depositor's money. That's where it comes from. Wow, it's quite a little scam. So it's highly important. That's why we reclaim our securities, overcome the presumption of abandonment, overcome the presumption of general deposit, overcome the presumption that we don't care. It's like, yeah, here's $500,000 for nothing, and now lend it to me, and I'm going to pay you back that $500,000 for nothing plus interest. As you know, in a mortgage, a $500,000 mortgage could be in the millions by the time it's paid. So, bank gets all of that for nothing. But all of that, the fruits of all of it is actually yours, because it's all based on your security and your signatures on the promise to pay. It's a financial asset. That's the asset. That's when you list your assets in bankruptcy or anywhere. Don't forget about the house, the car, the TV, the furniture. List the financial assets, the securities. So your kind of reaction you get when they do that one, as long as you know what you're doing. Some guy might be stupid, not have a clue like a trustee may not know what's going on here. Another one might know what's going on and test you. So, well, what's all this? You're listing these things as financial assets. They're not financial assets. So how are you going to deal with that? You want to be able to show them, well, actually it is. It says right here in this act, it is binding on the crown, is binding on the court. You don't have a hope in heaven here of overcoming this. It is what it is. And that's what I mean. That's another reason I say under paperwork and chit chat without the understanding is a waste of time, a crapshoot at best. You might get lucky. For the most part, probably not. Most people won't. And I don't think you want to go forward in your life based on luck. So a little bit of homework, study, research into reclaiming your securities, and we can, in a big way, more people step up to do this. Then that we start to take back from the 1%ers what belongs to us. Shift it back. Right now they got us all over here arguing and fighting. Well, they continue to play this game on us, and all of this, just like it says in our very first video, that clip I put out there from the book. It's mentioned in the first, Imperialism in America. You got this busy over here arguing about politics and left and right, left and Democrat and conservative and blah 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 blah, Green Party and blah 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 blah. Well, they're raping us over here. This is where we should be looking. Forget that nonsense, all of it. Where do the politicians, where are they getting their power from? We start to take that back, you see. You want to get to the root cause? I propose that this is the root cause. It's this legal plunder. Without that plunder, these entities would be nothing. There wouldn't be billionaires out there. There wouldn't be zillionaires out there. Not like there is, not at all. And the governments wouldn't be nearly as big as they are. The banks wouldn't be nearly as big as they are. These so-called, they call them, what do people call them? The elite. What do you mean elite? As long as you want to call them elite, I guess then they're elites. You want to keep calling them higher powers, and I guess they're the higher power. Once you bring them down to our level, stop using that kind of language. So, but anyhow, so this is what reclaiming your securities is all about. And there's different levels, one can go with that. So that's, just take it a little bit deeper into the reclaiming of securities and what's going on here. And if we really want to change things, then we're going to have to start looking at this stuff. Everything else is a waste of time. And if you want to get in this for selfish reasons, then that's beings of free will. You have the choice to do that. And as a fellow Marcus would say, to obey the law or not. There's a consequence still for non-abeyance. We're all in it. So yeah, anyhow, that should be about it for this. Hope that helps you in understanding. And like I say, if we go for the root cause of what I perceive, it's like I say, all those 1%ers now basically telling everyone else how to live their lives. Start taking that wealth back that belongs to us legally. And when I say legal, I mean these rules, like I say, Securities Transfer Act is binding on the Crown, UCC is binding on the government, it's basically binding on pretty well anyone and everyone that partakes in commerce. Even I just heard recently that not necessarily limited to that, but so your banks, your governments, corporate entities, so on and so forth, lenders, courts, judges, they're all making money off of our securities, every one of them. It's our securities. It's our property, belongs to you and I. If your signature's on it, it's yours. Everyone promising, it's yours. It's your financial asset. It goes on the books as an asset. For people in Canada, if you want to look up debts owed Her Majesty the Queen, the regulations, it's only a couple pages. Well, the act part is a little bit longer, but they give a list of what they accept as assets, bonds. It's all securities, basically. A bond is a mere promise to pay. And that's the assets, the form, the paper. This, not that, not this, not you and I, not in that system. So these assets are financial assets. That's what they call them, financial assets. So when you're talking in front of accounting, it's financial, right? So financial assets, not the house, this stuff. And through bankruptcy and insolvency proceeding, which can be really interesting for people if you understand this, what I'm saying here. Financial assets, they want a list of assets. Okay, assets. And that's what they owe me. The reason we're going bankrupt this year is because they won't give it back. So you, Mr. Anyhow, I'll shut up. Say some things are not meant for public consumption here. People really need to get the understanding of the principles and the concepts before you go forth with anything you see or hear in these videos. I mean, and I don't know where you're at in your path, your journey. You're being a free will at the end of the day, but there's nothing here that is advice, one iota. And I've said a few times, don't believe anything I say. Check it for yourself. I'm leading you to most of the statutes and legislation that's relevant, so you can have a look-see for yourself. That's it for this one. I'll stop talking here. Again, I love you. God bless. And food for thought, people. Ciao for now.